This presentation examines the findings of the United States Supreme Court decision Bearden v. Georgia in 1983 and discusses its application as to whether municipal courts may order a defendant incarcerated for failure to pay a court-ordered fine. The important safeguard of a show cause hearing is also discussed.
Bearden v. Georgia is the recognition by the United States Supreme Court that when people do not do things in a criminal case that involve money, that judges have a constitutional responsibility not just to commit them to jail, but to take a close look into the circumstances as to why that person did not comply with the court order that involved money. Bearden can be considered part of a trilogy. I like to think of it as a trilogy of cases that have to do with fines, costs, indigence, and incarceration. Williams v. Illinois was a decision that was handed down in 1970, and the issue in Williams, it had to do with what happens when a person is given a term of incarceration. Williams was sentenced to 1 year. He also was sentenced to a fine. And the question in Williams was, when you're sentenced to jail, do you have to stay in jail an additional period of time to discharge your fine? And in Williams, the court said no. The court said that Williams was entitled to credit. He could not be held an additional period of time simply because he didn't have the money to pay his fine at the end of his 1 year jail sentence. Tate v. Short came out 1 year later in 1971. It builds upon what the court said in Williams. Tate is about whether an indigent person who is sentenced to pay a fine and cost could have their fine automatically converted to a term of incarceration simply because they could not immediately pay the fine and cost. Once again, the Supreme Court said no. And so we tend to think of Tate v. Short as being the birth of alternative means. Well, just as Tate was built upon Williams, Bearden is built upon Tate. And what the court said in Bearden v. Georgia is that when a person receives a probation, and the probation consists of fines and costs, and the defendant subsequently defaults in the payment of the fines and costs, you cannot automatically revoke that probation and convert it to jail time. You have to give the person an opportunity to explain themselves. This is something that the judge has to do. You must give them an opportunity to appear in court so that the court can take a closer look at the specific circumstances of that person's case. At the heart of Bearden is fundamental fairness. I mean, Bearden stands for the proposition that to revoke probation in matters pertaining to money without considering whether alternative methods of punishment, let's say flexible payments, community service, without considering those things, it's fundamentally unfair and it violates the 14th Amendment. Bearden and Tate, they overlap, but they are very different. Tate ended the practice of pay or lay. Tate was specific to Texas. It was a case that began in a Texas municipal court, and it's very specific and easy to apply to municipal and justice courts and cases involving fine-only misdemeanors. Bearden is not only a probation revocation case, it's not a case from Texas. It does, however, have to do with fines and costs. So what courts have to do is they have to try to extrapolate the holdings of these cases and try to see how these cases work together, sort of like the Supreme Court did. Bearden generally stands for the proposition that courts have to make an inquiry into a defendant's ability to pay and consider alternative means before committing someone to jail. So when you take Tate and you take Bearden and you put them together, it can be understood that when a person is ordered to pay a fine and they don't pay a fine, the legally ideal best practice is to have that person come before the judge and be given an opportunity to answer questions about their ability to pay. And this is not just true for issues having to do with fines and costs. It's really ideal in any situation involving money. Tate made it clear, quoting Williams, that the state's not powerless to enforce its judgments, even against those who are financially unable to pay a fine. Indeed, if you did that, it would result in inverse discrimination. But at the exact same time, when Bearden cites Williams and Tate, it held that when the state determines that a fine or restitution is an adequate penalty, it can't imprison a defendant solely because of the fact that the defendant lacks the resources to pay. In Bearden, the court also said that if a probationer has willfully, and I'll stress the word willfully, refused to pay the fine or cost when he has the ability to, or has failed to make a sufficient bona fide effort to seek employment or borrow money, then the state is justified in using imprisonment as a sanction to enforce collection. Inverse discrimination is this notion that the law requires a level playing field. This really goes back to Tate. Not everyone has money in their wallet. Not everyone has money. So Tate stands for the proposition that the great equalizer in our society in these instances involving fine-only offenses is that we will give you an alternative means, but without putting them in a situation in which they're facing incarceration. That would be discrimination against the poor. Everyone has to have some consequence, and that in cases involving fines, alternative means, that is the equalizer. The court does not define bona fide. The opposite of bona fide is fake. And this is kind of just the dictionary definition. When we say that people are making a bona fide effort, it means that they're making a true, sincere attempt to do something. In Bearden, the Supreme Court did not define the term willful, and that has been a point of contention and a lot of discussion since the case was handed down in 1983. Critics claim that the omission of that term being defined really undercuts the holding. However, it too has a plain meaning, dictionary definition meaning. And Black's law defines willful as being voluntary and intentional. Because the laws of each state vary, there's quite a bit of variation in the ways that these states have implemented the Supreme Court decision in Bearden. Some states have chosen to try to take the holding in Bearden and merge it, take its holding, take the essence of the opinion, and codify it, make it part of the state law. Other states have chosen not to. Other states, they depend on judges to know what the Supreme Court said in Bearden and to apply its principles in instances where it's proper. Texas has kind of taken a blended approach. Texas, in certain instances, has adopted certain Bearden principles. In Texas, we have what's commonly referred to as a show cause hearing. Other states refer to this as a compliance hearing. Other states even call it an ability to pay hearing. I've also seen it called just a Bearden hearing. And in Texas, specifically in municipal and justice courts, in Chapter 45, there are two instances where the construct of a show cause hearing has been adopted. The first one is in instances of driving safety courses. When a person requests a driving safety course and they have failed to submit proof that they have taken the driving safety course, Texas law requires that the defendant be given an opportunity to show cause to explain themselves. Once again, the reason behind this is because taking a driving safety course costs money. Similarly, in our deferred disposition statute, we have a similar requirement that if a person fails to comply with the court's order, that the court shall, before revoking their deferred, give them a chance to explain themselves. Once again, this is not to a clerk, this is not to a warrant officer or to a prosecutor, this is to the judge. And once again, this kind of embraces this idea of there might be a reason that the person did not do what they were supposed to do, and it might have to do with money. Now, Texas is kind of, like I said, it's a blended approach. Texas has not adopted Bearden across the board in every instance that one might imagine. In cases in which a person is ordered to pay a fine, there is no express requirement in Texas law that there be a show cause hearing before the issuance of the capias pro fine. However, depending on how you read Bearden, it is a Bearden concept. Most courts, many courts in Texas, do, prior to revoking probations, set cases for show cause hearing. Now, Texas law does not require a show cause hearing before issuing a capias pro fine, but many people in Texas believe that it is required by Bearden. Once a person is arrested on a capias pro fine, the law requires that the person be brought immediately before the court or seen in a timely manner. And the hearing that's required by Article 45.045 and Article 45.046 of the Code of Criminal Procedure contains both Tate and Bearden procedural safeguards. There are disagreements between states and legal scholars about what Bearden requires. The best practice is to set a case for a show cause hearing whenever a defendant is not in compliance with a legal requirement. In light of Bearden, this is particularly true in matters involving money. So some examples would be, let's say, a non-appearance, non-payment, failure to comply with a deferred, failure to submit proof of a driving safety course, or failure to provide proof of complying with alternative means. Well, obviously, everyone who's asked to appear for a show cause hearing is probably not going to come. It is always in the court's best interest to be able to show to the public that they've gone through that step of giving that person to explain themselves. You know, some people might view a show cause docket as being just a waste of time, particularly if from experience they know that quite often people don't show up for these show cause dockets. But this is the reason why it's not only good constitutional law, it's also good practice. For those people who do come to a show cause hearing, and for those people who do present evidence to the court that shows a good reason as to why they did not comply, those people are not only in a position to have the judge reset their case or modify the order so that they can lawfully discharge the court's judgment, but that is one person who, by showing up and explaining themselves to a judge who was ready to listen to them, is not going to be subject to arrest, is not going to be taken to jail, is not going to be in a situation where they potentially risk losing their job or having their lives interrupted. In instances where a defendant fails to appear for a show cause hearing, Texas does have a procedural backup, if you would. And it's not something that comes from Bearden. It doesn't come from the case law. It comes from Chapter 45. So even in instances where we set these cases for a show cause hearing and the defendant does not appear, some of the same issues that are raised in Bearden are addressed when the judge conducts a timely commitment hearing. But there's something that has to be stressed about this, that assumes that the judge is going to know that the person is in the jail. And quite often, particularly in Texas cities, most cities don't have their own jail. They're dependent on the sheriff's department or the local jailers down at the county jail to notify them that someone has been brought to their jail on a capias pro fine. So it's critically important that the jailers give timely notification to the judge that issued the capias pro fine. It's equally important that the judges conduct timely commitment orders as required by Chapter 45. So when a capias pro fine is issued, we are required to do a commitment hearing and a commitment order. The benefit of the show cause hearing is that by holding a show cause hearing, you potentially end up doing less commitment orders because people come to court. The other thing that needs to be probably reiterated is that the capias pro fine is not the commitment order. It is just the beginning of the process. So by using show cause hearings, you not only potentially reduce the number of trips that you have to make to the jail, you also reduce the number of commitment hearings that you have to conduct. There are many unresolved issues about Bearden. There are questions that people continue to ask, predominantly legal scholars and trial advocates. Does it matter if there's a plea bargain? What if in the plea bargain the defendant explicitly states that he or she is not indigent? Does Bearden apply? What if the defendant failed to raise the issue in a timely manner? Is there waiver? So Bearden is a very significant piece of case law for municipal courts in Texas, but there are also a number of very significant questions that remain about Bearden.